This question came from one of our viewers. Do I need to have a codicil notarized to change an executor if the estate is under $100,000 in Illinois? Great question, and the answer might surprise you. In Illinois, a notary isn't actually required to make this change legally binding, but there are still a few important steps you need to follow. I'm Kevin O'Flaherty from O'Flaherty Law. Whether you're planning your estate or helping a loved one manage theirs, understanding the rules around wills and executors is key, especially if the estate is small and you're trying to avoid unnecessary complications. Let's start with what a codicil is. A codicil is a legal document used to make changes to a will, such as updating the name of the executor, the person who will manage the estate. In Illinois, you don't need to notarize a codicil. What you need to do is this. The person who created the will, known as the testator, must sign the codicil and must also be witnessed by two people who are not beneficiaries of the will. That's it. A notary isn't required under Illinois law, but having one can help the court accept the document more easily during probate. So does the size of the estate matter? Not when it comes to making a codicil. Even if the estate is worth less than $100,000, the same signature and witness requirements still apply. That said, Illinois has a helpful option called a small estate affidavit. If the estate is under $100,000 and doesn't include real estate, this affidavit may allow the family to bypass probate entirely. In those cases, who the executor is might not be as critical, because there may not be a formal probate proceeding at all. Still, if you're making changes to a will, it's best to get it right. Here are a few best practices. Even though it's not required, consider having the codicil notarized for clarity. Having an attorney review the document to make sure it meets all legal standards is also important. If you're making multiple changes, it might be easier and cleaner to create a new will instead of adding a codicil. To sum it up, you don't need a notary to change an executor using a codicil in Illinois, but the codicil must be signed and properly witnessed. And if the estate qualifies as a small estate, you may be able to avoid probate altogether using a small estate affidavit. If you're unsure whether a codicil is the right move, or you want help making the change correctly, give us a call. And if you want to learn more about Illinois estate planning and probate, the next video on your screen will help guide you further. Take care.